Did you know there are at least 18 sources of SEC guidance that you need to worry about? No wonder this crap is so confusing. Today on Zippy Point. I'm Brock Romanek. I'm a big fan of you, so even experienced practitioners might be alarmed. might be shocked to find out that there are 18 sources of SEC guidance, and there's actually even a few more than that. Some of them I just combined because some sources don't have a lot behind them, but geez, oh Pete. So much of the content I've been drumming up initially for Zippy Point is for the newbie lawyer. So I'm hoping to ease the transition for the next generation of securities lawyers by kind of breaking down this Byzantine practice of how we get guidance from the SEC. And one lesson that I've always wanted to teach but hadn't gotten around to was this research one. Where do you go to learn what to do? Seems simple enough. Well, simple enough. Yeah, I haven't seen anyone else put anything together like this that teaches it fully. So the SEC has this researching the federal securities laws through the SEC's website page. It's from 2012, so it's a little bit dated already, but that covers maybe a third of these 18 sources. Anyway, let's run through my 18 sources. So number one, statutes. So this source comes from the Congress, actually, not the SEC, but it's an important source, of course, because it's what gives the SEC authority to act in the way it does. So if the SEC ever gets sued because someone thinks the SEC acted without authority, the legislation is the basis for the lawsuit. That's what they're going to be arguing about. The SEC's webpage that I just showed, lists arguably what are the 8 most important pieces of legislation through the years. But there are many more than that touch on that make up the federal securities laws, some of which have been enacted since 2012 when that page was created, and then many more before that year, such as Private Securities Litigation Reform Act of 1995 that provides a safe harbor for forward-looking information. So some of the acts over the years have been enacted in reaction to crisis in the market, the Sarbanes-Oxley and Dodd-Frank being the most recent, and thus add to the burdens, the responsibilities that public companies have. And then some pieces of legislation seek to lessen the burden, particularly in more recent years, the FAST Act, the Jobs Act, as globalization increases, competitive pressure on American companies to succeed, and a lot of companies have elected to stay privately held because of those pressures. In fact, the number of public companies has dramatically shrunk over the past 20 years by 50%. That's pretty freaky. So the reality is that you may go through your entire career as a securities lawyer and almost never read actually the 33 Act and the 34 Act, which are the origin sources of the federal securities laws as we know them. We all have a tendency to focus on the actual rules and regulations from the SEC and not look back to the pieces of legislation that actually drove them. I'm not saying that that's malpractice. You can get away with that. But I would actually go ahead and peruse the actual statute, once every 5-10 years just to remind yourself why we're all here. 2, the rules. And then you have the rules that the SEC has adopted. You'll be spending a lot of time reading those. Those rules mainly are divided into 2 camps when you're a Corp Fin lawyer, the 33 Act rules and 34 Act rules. The 33 Act rules are for offerings, for deals. You have Regulation C, those rules, and some other rules. And the 34 Act rules are for periodic reports, the Form 8Ks, the Section 16 filings. And then you have rules for that, so you have Regulation 14A for the proxy, Regulation 12B for periodic reports. Section 16 has its own rules. The SEC has a rulemaking process that it has to follow. The Administrative Procedures Act, the APA, is the main piece of legislation that establishes the process that federal agencies must abide by when they propose rules, allowing a specific period of time to comment on the public to comment on them before they're allowed to adopt the rules. There's a timeline for that process, which varies depending on how big a rulemaking is. When the SEC conducts rulemakings, it will issue a proposing release for that proposed rule, and then an adopting release for the final rule. And those 2 types of releases are important to read, particularly the adopting release, because there will be gloss in there that you should learn about how the new rules should be interpreted. So it's a source of SEC guidance too, one that I'm not even counting towards my 18. In the old days, these releases were bare boned and had no guidance in them, but that's not the case anymore. They do have valuable nuggets in them, including in the footnotes. Always read the footnotes. There are a bunch of other laws that the SEC must comply with to conduct a rulemaking, all of which you really don't need to know much about unless you happen to work at the SEC and you're writing the rules. You have the Paperwork Reduction Act, the Regulatory Flexibility Act, and you'll see references to those laws in the back half of the SEC's proposing and adopting releases. The upshot here is that there's a whole lot of economic analysis in the back half of these releases nowadays, including how the new rule will impact capital formation generally and smaller companies specifically. Once in a while, the SEC will issue something called a concept release. This is a more general release. It comes before a rule proposal. It gauges interest from the public about a particular area of rulemaking, seeking input to help the SEC craft what its eventual rule proposal might look like if they decide to actually propose a rule. So all these releases are posted on the SEC's website in chronological order. Technically, these are not the official versions of the releases. The official versions are published in the Federal Register and then arranged by subject in the Code of Federal Regulations. But for your purposes, the releases on the SEC site are fine. Even though they're unofficial, they're identical to what's in the official version. 3, interpretive releases. So the SEC will occasionally provide guidance in the form of an interpretive release. These aren't rulemaking. It's the SEC at the commissioner level, not the staff level, taking a position on some existing rule, fleshing it out a little bit. The fact that it's at the commissioner level, the SEC's level, is important to know because if the guidance was ever challenged in court, it should hold up. In recent years, the ability of federal agencies to issue guidance at the staff level has been under attack, mostly from Republicans. So having guidance at the SEC level makes it far less likely that it's going to be attacked for not being legitimate. So a topic for another Vid-Guide for sure. This whole whether we need guidance from the staff. My take is yes. Anyways, for example, in 2018, the SEC issued this interpretive release on cybersecurity disclosure. You can see what those look like. 4, the forms and regulations. So I didn't want to forget to mention the actual forms themselves. The SEC has a bunch of forms, sometimes called schedules, that are what's required for the companies to file when they make filings with the SEC on Edgar. Edgar is the SEC's electronic database for all company filings. So you'll become intimately aware of what the forms say because you'll need to refer to them when you're filling out a Form 10K, a 10Q, an 8K, a proxy statement. That's a schedule. Forms 3, 4, and 5. And if you work on deals, it'll be a Form S-1, S-3, S-4. So these forms will refer, cross-reference other regulations that help fill in a lot of what goes in each form. But the forms themselves also have some requirements that's just in the forms and not they don't rely on a cross-reference. When they do cross-reference, the forms often refer referencing Regulation SK and Regulation SX. SK is what the lawyers work with the disclosure, and the SX is for the accounts, what the auditors will be drawing up. So note this is a high-level overview, and there are countless other forms, rules, and regulations I haven't mentioned. Countless, Regulation D, Regulation M, Regulation FD, Regulation G, Regulation BTR, Regulation ST, lots of them. So now I'm moving on to guidance from the SEC staff. So this Vid-Guide is not an hour long, and I'm trying to teach you all the securities laws in one video. I have lots of videos. 5, no action letters. So for decades, no action letters were the primary source of how the CorpFin staff got the word out. It's a strange process on its face. A company sends in a long letter saying, if we do this particular thing in minute detail, they give you in the letter, will it be okay if we do that? And the staff sends back ultimately a response saying, it won't refer you to enforcement if you go ahead and do that. So the responses are typically only a paragraph or two. But this happens only after there's been some back and forth, sometimes for months and months between the staff and company's counsel about what will be what's in the fact pattern that the response is reacting to. The staff almost never puts out a negative response. They just won't finish processing your request and you effectively withdraw it if you never change the facts to the point where they get comfortable giving you that favorable sort of non-answer that they won't send you to enforcement. And to cap it all off, the response when they give one isn't even supposed to act as precedent since it's based upon the specific facts in the request. Although in the past, sometimes the staff would process a big deal letter and add in a paragraph saying that this can be relied on, this particular no action response can be relied on more broadly. So the response really is in the vein of interpretive guidance. But in reality, these other less significant no action letters do serve as precedent, because when you're writing up your no action letter, you're going to cite older no action letters that have similar fact patterns to bolster your case. That's the definition of precedent. But these days, I'm not even sure the Office of Chief Counsel in the Division of Corporation Finance is even processing any no action letters from what I've seen, other than in the shareholder proposal context. And even then, a lot of those responses now are done orally. They're not in writing. The CorpFin's Office of Mergers and Acquisitions has continued to put out no action letters during 2020, but I've not seen many from OCC lately. 6, the compliance and disclosure interpretations. So this is where the real action in CorpFin is these days. Since 2007, the staff has had a host of these compliance and disclosure interpretations. They're arranged by rule and regulation type, and they're basically in a quasi Q&A format. And the staff usually adds a handful of new ones each year, depends on what's going on. Before they were called compliance and disclosure interpretations, which my acronym for them are CDIs. It was called the Manual of Telephone Interpretations, otherwise known as the phone interps. And before the web was born, back when I started practice, the phone interps were not widely known about. They were just, internal at the staff. I mean, I think if you filed a FOIA request, you can get a copy. So when you left the staff, you would take your prized possession, your manual, with you, because that made you real smart. And it wasn't illegal that you did that. It's just that there weren't a lot of copies of this thing around. History fact. 7, staff legal bulletins. So these are mostly for shareholder proposals, Rule 14A8. About every year or two, sometimes it's usually an annual event, but sometimes the staff will skip a year. The staff will put out a staff legal bulletin about the shareholder proposal process that happens in the fall. Occasionally, there's a staff legal bulletin about something else from CorpFin, and in other divisions they put them out too, but there's not a whole lot of action there. 8, CF disclosure topics. So there's been about 10 of these in the last 10 years. The last few in the last year about the virus. 9, sample letters. So this is a twofer. You have sample letters that the staff occasionally posts. There's a letter they're sending to the CFOs or CEOs of companies to remind them about something, like basically make a statement. And then you have staff reports every so often. This usually happens after there's a big rulemaking, and then the following year, the staff will have a project where they review a bunch of the filings to see how people complied with the new rule, and they'll put out a report. And in their report, there might be a little bit of new gloss about what they think about what's happening. They'll say, we've been issuing these types of comments frequently. Pay attention to what we're doing here. You're not quite following the rule the way we wanted you to. 10, comment letters on filing. So this is the bread and butter of what the Division of Corporation Finance does. You're making your SEC filings all the time, and sometimes they're selected for a full review, and then you're going to get a comment letter from the staff. Or they might fully review it and not have a comment letter. They might say there's no comments. But often there's comments, and then eventually that comment letter and your responses will be available on the SEC's Edgar no later than 20 business days after the review has been completed. So you can read through these comment letters to get a sense of what the staff has been commenting upon lately, sort of reading the tea leaves into the kind of things that the staff is concentrating on. And I have a separate Vid-Guide about this whole comment letter process. But the CorpFin staff also has a webpage that explains their comment letter process too. 11, staff statements. This has been a thing the past year in particular with the virus. The statements are highlighted on the right side of CorpFin's homepage. And then note there's also 2 policy statements back in 2014 and 2015. So that's a good example of the staff deciding we're going to have one new avenue of guidance, and then they start it and it lasts about 6 months or a year or two, and then that's it. There's a new division director. For whatever reason, they stop putting out guidance in that form. And that's why we end up with 18 types of guidance. Not necessarily. A lot of these are fully legitimate and are still running. 12, financial reporting manual. So this is on the accounting side of the CorpFin staff. This originally was the staff's own training manual for the accountants. I actually did a FOIA request way back when. I posted the training manual shortly on the corporatecounsel.net about 15 years ago. And then now it's been publicly available, and it gets updated much more frequently than it used to. And it's a really good resource for the lawyers too, to learn what you need to know as a lawyer about the accounting stuff. It's an easy read. 13, then you have the Office of Chief Accountant. So you have the Office of Chief Accountant within CorpFin, but then you have the SEC's Office of Chief Accountants. And occasionally they'll put out guidance that you'll need to know too. And So they have a set of FAQs that are for audit committees and auditor independence issues. Those are important to know when you're dealing with that issue. 14, staff accounting bulletins. So this is the bread and butter of what OCA, Office of Chief Accountant, puts out. There's been about 120 of them over the years. The ones that are on the SEC site pick up in 1995 with number 94. So you can see the average is about one a year that they put out a new staff accounting bulletin. Some are applicable to Corp Fin stuff and some are not. 15, Edgar. Okay, Edgar has its own web page. Of course, it's a big deal on the SEC's website because that's the Edgar database is where the companies are making all their filings, and that's where you can access them. But you need to know how to make the filing. So you look at the Edgar Filer manual. That's on the SEC's website. You have information up there about filing fees information and other resources on this SEC's Edgar page. 16, the Division of Enforcement. So let me start with Section 21A reports. They're essentially interpretive guidance. One of these come out every few years. For example, here's one from 2018 about deficient internal controls and cybersecurity breaches. These actually come out at the commissioner level, these 21A reports, not the enforcement staff level. And the SEC uses these 21A reports as a vehicle to signal how it views a particular problematic area, set of practices. So these are essentially like policy statements. And the SEC uses them to put people on notice that going forward, the SEC and its enforcement division are going to consider similar conduct fair game for more conventional enforcement action. Then, of course, you have all the enforcement actions themselves, and some of them will provide guidance about what companies can and can't do. And all these are listed on the enforcement division's webpage. They usually have a press release, and then you actually have the complaints and settlements and all kinds of guidance you can glean if you start reading those. There's actually an enforcement manual on the enforcement division's webpage. That's a good way to learn about how the enforcement division processes, what their processes are and how they process an investigation. So if you want to get up to speed on that, I recommend you read that. 17, okay, now you have speeches. So you don't see there's written speeches up on the SEC's website. You don't see too many written speeches from members of the staff from the Corp Fin. If you do, it's almost always from the director. I've seen the deputy director, I think, have one written speech that was delivered at one of our conferences back in my old job. The SEC chair and the commissioners are delivering speeches all the time, however, ones that get written up and posted. Some are more important than others, of course, and some relate to public companies, and a lot of them don't. 18, the last one I'm calling lore. I'm calling this last one lore because it captures those remarks made by Corp Fin staff that aren't reduced to writing, so the word gets around as to certain positions the staff might be taking. So there's a number of staffers, director to deputy director, but even below that it might be out and about speaking, or it might be about a particular type of enforcement investigation that seems to be popular right now, but no case has actually been brought to the finish line just yet. So you're starting to put your ear to the street and you're hearing, oh, this is a sensitive topic right now. And so you tell your clients, you better change your practices here because enforcement is sniffing around. So lore is my favorite type of SEC guidance. You can smell it, you can hear it, it's out there, but you just can't quite see it. Okay, so things change, of course, over time. So this video could be outdated in a month. Who knows, at least little pieces of it. There could be a new source of SEC guidance, but let me know what you think.